Imagine finally saving enough money to purchase a Spanish beachside retreat, only to discover a new law might impose a tax so high it effectively doubles the cost of your investment. That's the buzz surrounding Spain's rumored plan to levy 100% tax on property purchases by non-EU nationals, a proposal that has sparked intense debate among legal experts, economists, and prospective buyers. Over the next minutes, we'll explore why Spain is contemplating such an extreme measure, how it could conflict with the Treaty of the Functioning of the European Union, and whether it violates key EU principles like the free movement of capital. I'll also reference relevant case law from the Court of Justice of the European Union to illustrate the legal challenges Spain could face. Spain's real estate market has long been a magnet for foreign investment, from the urban allure of Madrid and Barcelona to the sun-soaked Mediterranean coast. International buyers, often from the outside the EU, have helped drive up property prices. For many local residents, this surge translates into mounting affordability issues, with many middle and lower income households feeling priced out of their own neighborhoods. To address these challenges, some Spanish lawmakers have proposed a property tax specifically aimed at non-EU buyers, potentially as high as 100% of the purchase price. The reasoning is that if foreign investors are a key driver of rising prices, then a steep levy could deter them, cool the market, and make housing more accessible to locals. However, this idea raises significant questions about Spain's obligations under EU law, especially concerning non-discriminatory and the free movement of capital. To understand the potential legal pitfalls, let's turn to the Treaty on the Functioning of the European Union. Two provisions are particularly relevant. Article 63, which is the free movement of capital. This article forbids all restrictions on the movement of capital between member states and between member states and third countries. Real estate transactions are typically classed as capital movements. A 100% tax could be interpreted as a near-prohibitive barrier to non-EU investors, prompting allegations that Spain is in direct violation of Article 63. The Court of Justice of the European Union has frequently struck down national measures deemed disappropriate under Article 63. Examples include Commission versus Portugal and Commission versus Italy. In these rulings, the court emphasized that member states must prove their restrictive measures are necessary and proportionate to a legitimate public interest. And Article 18, non-discrimination on grounds of nationality. While this provision specifically protects EU citizens, the broader spirit of non-discrimination infuses all EU policies. Targeting non-EU nationals exclusively can attract legal scrutiny. Even though non-EU buyers don't enjoy the same rights as EU citizens, a policy blatantly aimed at excluding them could still conflict with EU principles, particularly if it substantially impedes the flow of capital. Under EU law, restrictions on capital flows can be permissible if they meet a stringent test. There must be a legitimate public interest objective, and the measure must both be necessary and proportionate to achieving that objective. If Spain relies on tackling a housing crisis as its justification, it must still demonstrate that no less drastic alternatives, such as moderate surcharges, support for local buyers, or tighter regulation of short-term rentals would suffice. A 100% tax on non-EU buyers effectively creates two categories of investors: EU nationals, who are exempt from this extreme measure, and non-EU nationals who face a potential doubling of their purchase cost. Critics argue this is a classic case of discrimination based on nationality or origin of capital, even if the end goal, affordable housing for locals, is commendable. Such a heavy-handed approach might be seen by the court as an overreach, violating the principle of free movement of capital. Supporters of this measure commonly cite housing affordability. By discouraging wealthy foreign investors, local buyers might regain a fair chance in the market. And social cohesion. Properties used solely for vacation or short-term rentals can leave neighborhoods half empty for much of the year. A hefty tax could reduce these vacancies. And also funding for public housing. If some non-EU buyers proceed regardless, the significant tax revenue could be allocated to affordable housing projects. Although these policies could be deemed legitimate, the ultimate question is whether Spain's approach is proportionate. The court will likely examine whether a slightly lower tax rate, specific regulations on holiday rentals, or other targeted measures could achieve similar results without essentially barring non-EU investors altogether. If you're enjoying the presentation so far, please consider leaving a like and subscribing. Let's continue with the presentation. If Spain were to implement this policy in its most severe form, a few key scenarios might unfold. Legal showdowns. The European Commission could initiate infringement proceedings under Article 258, alleging that the Spain's policy violates Article 63. Meanwhile, private parties, like foreign investors or Spanish realtors, could challenge the tax in Spanish courts, which may then refer key legal questions to the Court of Justice. Economic repercussions. Real estate, construction, and related services are major employers in Spain, partly fueled by foreign capital. A sharp downturn in foreign demand could destabilize these sectors. While local buyers might see price relief, the broader market could contract, affecting jobs and tax revenues. EU-wide precedent. Other EU nations, also grappling with soaring property prices, might keep a close eye on Spain's experiment. If the measure is struck down, it reaffirms the dominance of EU law and the free movement of capital. If it somehow survives, it could embolden similar processes across the bloc, but that seems less likely given the established case law. All things considered, Spain's proposed 100% tax on non-EU property buyers stands on precarious legal footing. The measure's intent to address legitimate housing woes is understandable. However, EU jurisprudence has repeatedly underscored the importance of proportionate, non-discriminatory policies that do not hinder the free movement of capital beyond what is strictly necessary. Unless Spain can convincingly show that no other less restrictive approaches could fix its housing crisis, this proposal is likely to face formidable challenges, both in court and in the court of public opinion. Ultimately, it highlights a persistent tension. How far can an EU member state go to protect domestic housing interests without overstepping the boundaries set by EU law? Thank you for listening. I'll see you in the next one.